Many people choose to represent themselves at trial. At times, they may have questions regarding how a trial is conducted. In this video, we will walk you through how a trial is conducted.
The case will be called by the judge, and the prosecutor will sit at one table and the defendant at the other. In the majority of cases, the officer that wrote the ticket will sit next to the prosecutor. Once the parties are seated, the judge will read the complaint against the defendant. At this point, both the state and defendant have an opportunity to make a brief opening statement as to what they believe the evidence will show. The state goes first, followed by the defendant. The parties can also waive the opening statement and proceed with testimony. The state has the burden of proof beyond a reasonable doubt on a criminal charge. That means the state always has to go first. The state will call its witnesses to testify, and that witness will be sworn in by the court. After the witness is sworn in, the state will proceed to ask that witness questions about the case. This is known as direct examination. When the state is through questioning the witness, the defendant then has an opportunity to ask the state's witness questions about the case. This is called cross-examination. When the defendant has finished questioning the state's witness, the state may ask that witness further questions. This is known as redirect examination. This procedure is followed until all the state's witnesses have testified. When the state rests, the defendant can call witnesses to testify on his or her behalf. After the witness is sworn in, the defendant can ask that witness questions about the case. When the defendant is done, the state can cross-examine the witness. When the state is finished, the defendant can ask further questions. This procedure would be followed until all the defendant's witnesses have been called. The defendant may also testify on his or her own behalf. In a criminal case, the defendant has a right to remain silent. Therefore, a defendant never has to testify, and that cannot be used against the defendant. If the defendant elects to testify, then the defendant would testify about the facts of the case. When the defendant is through testifying, the state would then have an opportunity to ask the defendant questions. When the state is done, the defendant can give follow-up testimony. After the defendant has presented his or her evidence, the defendant would rest. The state would then have an opportunity to present rebuttal testimony. The state would call the witness and ask questions, and the defendant would then have an opportunity to ask his or her own questions of that witness. When the defendant is done, the state can ask follow-up questions. During the trial, both sides might also introduce relevant exhibits or documents. For example, if a witness was asked to draw a diagram of an accident scene, the drawing would be marked as an exhibit. After the witness testified about the diagram, either side could ask that diagram be admitted into evidence. If the court admitted the exhibit, then it would be considered part of the evidence in the case. After all the evidence has been admitted, both sides get to give what is known as closing argument. It is a recap of the facts and how those facts support your position on the case. The state goes first, followed by the defendant. When the defendant is done, the state gets to go again, since it has the burden of proof in the case. The closing argument must be based on the evidence presented. You cannot argue facts or evidence that was not admitted during the trial. For example, you cannot talk about what individuals who did not testify at the trial would have said, or talk about documents that were not admitted into evidence at the trial. After both parties have concluded their closing arguments, the judge will enter a finding of guilty or not guilty as to each charge. If the defendant is found not guilty, the case is over, and the parties would exit the courtroom. If the defendant is found guilty, the court would normally proceed to sentencing. The state could make a recommendation as to the sentence. If there was a victim in the case, that victim could address the court regarding sentencing. When the state is done, the defendant has the right to address the court regarding the appropriate sentence or give other information the defendant believes the court should know about prior to sentencing. When the defendant has finished, the court would pronounce the sentence.
Good.
If the defendant is found guilty on any of the charges, the defendant has a right to appeal the court's decision to the Maricopa County Superior Court. Information on the appellate process is provided to the defendant in writing just after sentencing.